Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And today we'll be focusing on what I believe is pretty much the conclusion of the Ronald Greene trial. And you may recall back on June the 25th we said that trial was on life support. And now we can pretty much officially say that the life support plug has been pulled. And it appears that the prosecution is poised to drop all of the charges, specifically for what was to be the trial on October the 28th with regard to Corey York. And what I want to do in this feature is to focus in on why I believe that they have had little choice but to go ahead and drop those charges. First of all, it took 7 months for the defendants to even really have it be known what they were charged with. You may remember that each of the defense attorneys fought for what's called a bill of particulars, for it to be itemized exactly what they were charged with. That took 7 months. So that took us into July of 2023 before they really even knew what the specific charges were. In the immediate aftermath of the bill of particulars, District Attorney Belton really had no choice but to drop the charges against John Clary, and we'll give you the link for that feature. I'm not going to go into the details of it because it's all right there, already outlined for you. And I know that Mr. Belton spun that to Ms. Harden as being a flip. It was not a flip. Again, we'll give you the link for it so you can go in and see. But Mr. Belton had no choice but to drop those charges for the simple reason that John Clary was not guilty of what he had been indicted on, and the evidence was overwhelming and irrefutable to the contrary. But within that subcategory, I want to focus in on that if this trial were to proceed, there were going to be severe credibility issues with regard to Albert Paxton. In fact, I could argue, and I am arguing, that I think there's a good chance that Paxton, who would have been the star witness, would actually need to plead the fifth. And the reason I say that is, you will remember, and it's part of that Clary feature, just look at the video. Mr. Paxton could not keep his story straight for even 20 minutes at a legislative hearing involving Ronald Greene regarding when the Clary video surfaced. At one point he said it was in early September of 2020. Later he said it didn't surface until around early May of 2021. Well, that's a 9-month gap right there that Mr. Paxton knew about the existence of the Clary video, and yet he didn't turn it over to Mr. Belton until May of 2021. So I think his credibility would have been severely called into question. And in fact, I believe that the evidence is stronger. Well, I know it's stronger that Albert Paxton withheld the body cam video than the evidence against John Clary, which is kind of ironic considering that Mr. Paxton was Clary's chief accuser in that regard. So, and beyond that, we'll reproduce once again the initial incident report that Mr. Paxton signed with regard to what happened in the Ronald Greene matter. Now that report is not dated, it's not timed, but one would presume that he would have watched the Dakota DeMoss video, which is the far more damning video, and he does not even dispute that video he had. So to write up a narrative that is completely contradictory to what is reflected on that Dakota DeMoss video, only he can explain. To me, it has to be one of two things. Either it has to be you didn't watch the video, which would beg the question of why not, since you had it, or did you watch it and report this anyway? So I think you can see the clear and obvious credibility problems that Mr. Paxton would have had if this trial were to proceed. And in theory, we still have one defendant left, that being Christopher Harpin. He's the sheriff's deputy. I believe many of these same problems would exist even if his trial ends up going. The second major problem, that was the first problem as a subset within the overall Clary problem. But going on to the next broad category, you had some potential expert witness, or one in particular, one expert witness potential problem. The record shows that there were returned subpoenas for the three experts, that being Dr. Forsythe, Dr. Stoughton, and Dr. Peretti. Now, Dr. Stoughton is PhD, not medical doctor, but pertaining to use of force from South Carolina. And so I reached out in an email to Mr. Hugo Holland. He's the one who is providing assistance to Mr. Belton. In reality, would probably try anything that would ultimately ever be tried on this matter. And I said, look, I'm a little baffled at why you would need to subpoena these witnesses, given that they're your witnesses. And so I asked Mr. Holland, this is a couple of weeks ago, look, is there expert testimony going to be available or not? Mr. Holland opted not to reply to that email, and so what I did is I sent very short emails to each of those three expert witnesses, Dr. Stoughton, Dr. Forsythe, and also Dr. Peretti. Dr. Forsythe and Dr. Stoughton were gracious enough to reply and say that they now had the subpoenas and that if called to testify, they would certainly testify. Dr. Peretti, on the other hand, did not reply. Now, he is an absolutely critical witness because he is the one that wrote the second autopsy report. So I'm not going to say they didn't have the benefit of Dr. Peretti, but if they did not, that was going to be a huge problem, which is why I believe they're poised to just simply drop these charges. But beyond that, I want to go to the issue of Seth Stoughton, the use of force expert. I can assure you the defense attorney, J. Michael Small, was salivating at the opportunity to cross-examine him. We all know from past features, if you followed them, that when Robert Talley interviewed Corey York in Internal Affairs, he let him know, hey, nothing you say here can be used against you in a criminal proceeding. And that we now know that through an affidavit, Mr. Stoughton, or Dr. Stoughton, I'm sorry, listened to. He put in an affidavit that he listened to the entirety of that recording. Well, I'm sure that J. Michael Small would say, well, why, when you heard those words, nothing you say in this can be used against you in a court of law, in a criminal proceeding, and knowing that you're working for the prosecution in a criminal matter, why did you not say, look, I obviously got this by mistake, I did not listen beyond that point? So I think that would have been a serious problem. In fact, I would have suspected that J. Michael Small would have moved to suppress the use of force report. And in my own opinion, I think he would have had very strong grounds for such a motion to have been granted. And that would have certainly did a almost insurmountable harm to the prosecution's case, as if everything I've already outlined is not bad enough. And that's going to go back to this whole Castigar motion. You will recall that I said on several features that I felt like the Castigar motion ought to be granted. It was not granted by the trial judge. It was not granted by the appeals court, who basically didn't hear the matter. They just said denied without providing any elaboration. Ditto for the Louisiana Supreme Court. I'm going to be perfectly blunt with you. I believe that the reason that that's the way that Castigar motion was handled is this whole case was viewed as a hot potato, and nobody wanted it on their hands that they were the ones, be it plural for justices of a court, to be it Louisiana Supreme Court or a Court of Appeals, nor did the judge want it on his hands or their hands that they were the ones who dismissed the matter by way of granting the Castigar motion. I still continue to maintain the Castigar motion should have been granted, and I think everyone can say in hindsight it would have made this whole process a lot more efficient if it had been granted. Now, last but certainly not least is the level of cocaine concentration that has been reported to be in Ronald Greene's system, and particularly Now this is all part of a motion for, basically a Brady motion that Mr. Small made, which is in the public record, and we're going to provide it to you. But there's an interesting email exchange between Hugo Holland and J. Michael Small about whether or not a toxicology report was ordered. It turns out that apparently there was not. However, in an email, Mr. Holland volunteered to Mr. Small that we have been able to ascertain that the cocaine level in Ronald Greene's system, it was reflective of 1,700 nanograms per milliliter, 1,700 nanograms per milliliter, and he also got specific as to say we can pinpoint that that originated from the heart and not from an ancillary organ. And I'm quoting on that. That came from the heart and not from an ancillary organ. Mr. Holland also volunteered that the average cocaine level for deaths from cocaine ingestion is 908 nanograms per milliliter. So you're looking at very close to double that level being from Mr. Greene. And Mr. Holland cited a four-person study on that for his number of 908 as being the average. So this has been a rather short video because I think I've hit all of the major points, and it certainly looks like the prosecution is poised to drop the charges against Ronald Greene, at least where it concerns Corey York, which would have been the upcoming trial this Monday. And that's only going to leave Christopher Harpin. But I see these problems sticking around for Christopher Harpin as well. The only other thing, there's a chance there may be a plea deal rather than an outright dropping of the charges, but even if that happens, it's going to be, in my opinion, so close to the dropping of these charges that it's really not going to be any meaningful difference. So with that, this is Robert Burns. We originally broke the Ronald Greene story on September the 10th of 2020. This is certainly not the conclusion of the criminal matters because, as I said, we have Christopher Harpin remaining. Thereafter, the civil matter can proceed because it has been, as I previously reported, placed on administrative hold until all criminal proceedings are completed. So we have pretty much largely, though not completely, but largely come to the end of the Ronald Greene criminal matter, although, as I said, the Christopher Harpin matter still does hang out there. And by the way, one last thing, in light of all this, or what was anticipated on all this, there was a filing made by Christopher Harpin's defense attorney, and it's basically that his trial, which was scheduled for next month, November, has now been continued to an unknown date in 2025. So with that, that pretty well wraps it up. We're going to give you the support documents, but I've covered it all pretty much in this video. We thank you for your dedication, for all of you who have followed the Ronald Greene matter, as well as all other matters pertaining to state police. We look forward to bringing you another Sound Off Louisiana feature in the very near future. Thank you so much.